Final case.
Please support. I'm Glenna Joyce Reeves, and I represent the appellant, John Casey. I'd like to...
You might want to pull the mic up towards your... That might help a little bit.
Okay. I'd like to reserve 3 minutes for rebuttal.
All right.
And unless there's questions, I'd rely on my brief as to Issue 2 and would like to discuss Issue 1 today. Mr. Casey was charged with armed robbery of a gas station, and the sales clerks immediately claimed to recognize him as someone, or recognize the robber as someone who frequented the store. On a surveillance tape, you could hear the clerk say that the robber was this crackhead who comes in here all the time. The sales clerks also testified that they had had conversations with Mr. Casey in the past, and he had told them that he was on crack cocaine, that he was homeless, and he'd been kicked out of his house by his parents. Before the second trial, the appellant moved in limine to preclude this testimony from being introduced at trial.
In this particular case, and I don't disagree with the general proposition that we don't want to use epithets to try and get the jury preconditioned against defendants in criminal cases, but in this particular case, weren't those descriptors critical to explaining how the witnesses were able to positively identify this man? I mean, if you took that out, how would the jury know why these people were so sure it was the same guy?
Well, I think the descriptions of him aren't critical to their identification. What's critical to their identification is that they saw him before, and they had conversations with them before, and the length of time of their conversation.
They knew it was the same guy because they knew him as a homeless crackhead.
Well, they knew that doesn't identify him as the robber.
Okay. Because the trial judge did give a limiting instruction here, didn't he?
He limited it to identity.
And was that instruction objected to?
Well, under the statute, anytime collateral crime evidence is given, you're entitled to that limiting instruction. And
well, you can request that it not be given, though, can't you? Because a lot of defense lawyers think that actually reinforces in the jury's mind the bad stuff that's already been testified.
Well, it was given without objection here.
Now, you mentioned a motion in limine being filed before the second trial.
Right.
Weren't there two filed even before the first trial?
There were 3 trials in this case. And so before the second trial is when the actual motions in limine were filed. And there were 2 motions in limine. One was directed to the videotape, and one was directed to the homelessness testimony. At the hearing that was before the second trial, the...
Okay, so one motion said exclude the videotape.
Correct.
And the other said exclude the videotape and any other evidence of homelessness.
The testimony as to homelessness, because on the videotape there wasn't any reference to homelessness. At the hearing on the first motion in limine, which was the motion itself was limited to the videotape, the hearing made it clear that they were encompassing the testimony of the clerks as well. And the trial judge made a specific ruling that his ruling as to identity would apply to the testimony as well as the videotape. And that's volume 2, page 214.
They didn't give away the homelessness issue?
The judge made a ruling that his same ruling applied on the homelessness issue too, and that's at 218.
All right, you say there's nothing, there was nothing on the tape about homelessness
Correct.
or about his being thrown out of his parents' home?
Not that was played before the jury. That came in through the testimony of the clerks.
Okay, and then the second motion, they wanted to exclude testimony about his carrying a gun.
There were three aspects of the second motion, and the third aspect of it was related to homelessness. And so that's what's pertinent here. The thing about him carrying a gun was granted, but the homelessness issue was denied, and as I said, that's page 218.
Okay, so when we're talking about matters outside the videotape, we're just talking about the information that he was homeless.
And that he was thrown out of his house, and that he was on crack. There's that.
Well, now, the second motion doesn't say anything about the crack, does it?
No, that's the first motion.
And the first motion is restricted to the tape.
But during their conversations at the hearing on the motion in limine, it's clear that they're talking about both the testimony and the videotape. And the judge makes a specific ruling that his ruling allowing it as to the videotape also applied to the testimony. And then before the third trial, the judge made an indication that his ruling that he had made at the second trial with respect to the testimony and the videotape would remain the same. And at that point, the defense renewed his motions in limine. And I think it's clear during the March 1st trial, when the testimony came in on the store clerks talking about him being on crack cocaine and him being homeless, the defense objected, arguing that they were objecting based on their prior motions in limine. And the trial judge denied, saying on that same ground. And
Was March 1st the third trial?
That's the second trial.
At the third trial, did the crackhead comment in the videotape come in?
The crackhead on the videotape came in.
It did?
I believe it did, yes.
So when you say, I believe it did, you could not give us a record site?
No, sir, I don't have a record site.
Now, didn't the girlfriend say that he was a crackhead, a homeless crackhead?
Well, it's not a girlfriend, but a friend. She testified that she was a crack addict. But in reviewing her testimony, I did not see where she said that he was. She said that she was homeless. In reviewing her testimony, I did not see that she said that he was homeless.
I see.
Part of the state's identification of Mr. Casey was based on voice. So I would concede that the fact of prior conversations and the length of time that the clerks had had conversations with Mr. Casey would be relevant to the issue of whether or not they were familiar enough with his voice to be able to recognize him. But it's our position that the substance of those conversations simply is not relevant to the question of identity.
Well, it's undisputed they didn't know his name, isn't that right?
That's correct.
And this was sort of like a spontaneous statement made at the time of the robbery. I know who he was. He's that homeless crackhead who comes in all the time. Or something to that effect. What if instead they had said, I know who he was. He's the guy with the big nose who comes in all the time.
Well, that doesn't contain collateral crime.
Well, no, of course it doesn't, but, I mean, isn't it the same sort of thing? Aren't they just trying to identify him?
Well, even if that is identification in some sense, it would only be minimally relevant. And the prejudice outweighs any relevance that there is.
Even with the limiting instruction that was given?
Was that, if you'll answer Judge Webster's question, I have a question for you.
Well, I think the limiting instruction isn't sufficient. And that's based upon the fact that bad character evidence is presumptively harmful. The evidence here was not overwhelming. And
weren't there like 3 or 4 positive IDs? Including his girlfriend? I mean, the woman who hung out with him.
Two IDs by the clerks and
this woman.
This woman who says that she allegedly heard a confession.
Did all those IDs take place in the first trial?
In the Heather Gwynn didn't testify in the first trial, the best I can tell.
But the two people who were in the store did testify.
They did testify, and that was a hung jury in the first trial.
Well, was the objection made that the prejudice outweighs the probative value?
Yes, that was in the argument on the motions in limine. That was part of the argument. Before the second trial.
All right, and we've already talked about one of those motions went to the tape, and the other, insofar as pertinent, went more generally to any evidence of homelessness.
Right. And it's my position that the motion that was in writing limited to the videotape in oral argument was essentially amended to encompass the testimony, because the clerks testified that he was on crack and that he was homeless and he'd been kicked out of his house by his parents.
You say the motion was orally amended?
Well, not in a
not
form,
explicitly. Right.
Not explicitly, no, sir, but in the discussion. And the judge made a specific ruling that his same ruling would apply with respect to the testimony. So, I mean, I think everybody understood that the objection was to both the videotape and the testimony of the clerks.
But even under that view, it wouldn't pertain to the so-called girlfriend's testimony?
Well, the homelessness would.
You're into your rebuttal time, Ms. Reeves, if you want.
Okay.
We'll reserve that for you. Thank you.
Good morning. May it please the Court. Giselle Island Rivera on behalf of the state of Florida.
Were no motions filed before the first trial?
There was one that pertained to the tape, references to crackhead. Yes, Your Honor. Appellant claims, however, that there was a blanket objection to all this testimony, and I think it's very clear from the record as well as the Court's questions today that not everybody was on that same page. Specifically, when we look at the hearing on 228, while they are arguing this, everyone's talking about the tape, and I would refer to 207, 208, 212, 214. Everyone's talking about the tape, and it's pretty clear that everyone is relating the objection that is being argued to the tape itself. And nothing at all really reflected Ms. Gwynn's testimony at all. At trial, appellant got up and waited until after Clerk Vondrek had already testified, saying that appellant would come by the store periodically and bum cigarettes, and they would give him drinks and food and whatever. And when Mr. Sandrini got up, then finally the objection was to relevance. However, at record 205, they conceded that it was relevant. So the only objection at that point would have been whether probative value was outweighed by prejudice.
Okay, so originally the ruling on the motions was denied, but you can restate the motion or an objection at trial.
Correct.
And Vondrek testified without objection.
Correct.
To homelessness and crackheadedness?
He didn't call him a crackhead. I don't remember if he called him a crackhead, but he certainly testified that he was there bumming food and drinks, and they were allowing him to use the bathroom, et cetera, et cetera. So the implication was that he certainly was homeless and impaired financial straits.
Well, somebody related the conversation in which he said his parents had thrown him out of the house, right?
Mr. Sandrini did, and this was also a part of what was on the surveillance tape, because the surveillance tape is running, and as soon as the appellant exits the premises, one turns to the other and goes, you know who that was, you know who that was that crackhead who comes here all the time and hangs out. And immediately they pick up the telephone, they dial 911, and you can hear the clerk's side of the conversation with the operator, and he's saying, and obviously she's asking him, how do you know this person? And he's saying, well, that's the homeless crackhead that hangs out here all the time. So that's how this all ties in. Clearly,
and that you agree with the opposing counsel that came in at the third trial?
Yes, sir. Absolutely. Clearly, this is a case where it was critical, as Judge Webster pointed out, to the identification. The appellant made much of the fact that this was
their familiarity with this fellow could have been developed without pointing out the fact that his parents had thrown him out of the house and that he used crack cocaine and was homeless, couldn't he?
I don't think so under the facts of this case. First of all, homelessness is not a crime. It's not a collateral crime. It's an egregious circumstance.
Using crack cocaine is. And,
absolutely.
And there's some shame associated, and a lot of people look down on homeless people. They probably shouldn't, but they do. And I'm just having difficulty. I can understand why it's important for them to make the point and have it developed through their testimony that this guy had been in there a lot and they'd heard his voice and they'd seen him and all of that, but I don't know why. I'm having difficulty understanding why all that stuff needed to come out. And maybe it wasn't preserved. You may well be right about that, but this just seems to be a matter of degree to me. What if they'd said that's that liar who comes in here all the time, that's that wife beater who comes in here all the time, that's a convicted murderer who comes in here all the time? Are we just looking at these things across a continuum and deciding when it gets sufficiently bad it's unnecessary?
Well, in this case, I think it was necessary. Appellant's entire theory of the case was that he was misidentified. And here you've got clerks. It's a very short robbery. How many people does the average convenience store clerk look at over the course of a year? They had to show that there was a specific reason they knew this person and they knew intimate details about his life that were independently verifiable, that were verifiable. We don't have names. We don't have any other information.
What was the independent verification?
Excuse me, Your Honor?
What was the independent verification?
I'm saying the facts that he was homeless and a crackhead were things that could be independently verified to establish that the reliability, the underlying reliability of their identification. And
I'm having trouble following that. The fact that they are saying that the person who did this is a person who comes in who has all these qualities. How does that verify that their identification of the person there that they saw was that same person? The fact that it can be gone out and verified that he had been thrown out of his house, that he used cocaine and these things, I don't understand how that gives any more strength, unless there's some question about whether or not they were telling the truth about what he told them. But that's not an issue here, is it?
No, it's not. But it is a question because they actually tried to impeach everything that these persons did to identify him. Not only did they assert that they were nervous, they couldn't pay attention, that the gun was in their face, that they're not looking at this person, they also attacked the fact that when these individuals were brought down to the police station, they were shown approximately 3,500 different photographs and selected somebody who they said was similar and then tried to say they misidentified the appellant because they said this guy was similar even though they never said that was the person. So it was important to establish identity, and the court did read a limiting instruction. It's presumed that the jury follows those instructions. There's no evidence to the contrary. And as was conceded today, appellant never asked that the instruction not be read. It's also admissible to prove the state of mind of those individuals, both to rebut the defense but also to explain subsequent acts, such as the fact why they did pick a picture of someone who was quote-unquote similar. So state of mind applies. More importantly, I think also, these were spontaneous statements that were made by these individuals. They certainly would have been admissible as hearsay for that reason, excited utterance or spontaneous statement.
Yeah, but
And-
the simple fact that they might be admissible as hearsay doesn't necessarily answer the question of whether the potential prejudice outweighs the probative value.
No, it doesn't, but it goes to harmless error as well, and I think you have to look at that.
Judge
when-
Allen has pointed out, I think, that there were 2 hung juries in previous trials, weren't there?
We don't know what the basis for that was, Your Honor. I mean, that's pure speculation on our part as to, figure out why these people decided they were going to hang on that jury. I mean, it very well could have been that they might have felt he was completely guilty, but they felt very sorry for him. And I think most people do feel sorry for people who are addicted to drugs and homeless. The state's also entitled to present a complete picture of what happened. And given the fact that there was a cautionary instruction, that's what happened in this case. The state would respectfully assert that there was no error. If the court disagrees, I would ask you to seriously look at my harmless error argument in this case. This videotape was cumulative to other unobjected to testimony. Mr. Vondrak testified without objection as to these elements. In court, Mr. Stondrini testified initially that when he made his in-court identification that appellant looked healthier and clean and all these other things, no objection there. We've got Heather Gwynn. She testifies that she's hanging out on 103rd Street, that she's homeless and she's a crackhead and smoking crack and dealing drugs and all other kinds of other things, and that she hangs out with appellant. And she testifies about an incident that happens the morning of this crime, where she's coming off the high, she's looking to get on to another one. She goes to the apartment of apparently a drug dealer. There's another drug dealer present, and appellant is present, and she smokes. The implication clearly is that they're all smoking, and they're all hanging with these people. We've also got the 911 call, which was encompassed within the videotape. Even if we didn't admit the videotape at all, the surveillance tape, very clearly we could have admitted the 911 tape without problem. All of the victims made multiple identifications of him. Additionally, Ms. Gwynn testified that with regard to the videotape that she viewed, the original, she recognized appellant and identified him based upon his voice, which is not covered by anything. And then on the second, she also identified him based on appearance. She also testified that appellant confessed to committing the crime that morning when they're all in that apartment smoking crack cocaine. Lastly, the court would again point to the cautionary instruction, and with all due respect, I would ask this court to affirm. Thank you.
Thank you, Mr. Barrett.
Could you address the harmless error condition?
Be glad to. It's my position that the evidence here is not overwhelming. Of course, that is not the test under DiGiulio. But I would point to the fact that the sales clerks, although they testified in the first trial, there was a hung jury in that trial.
The confession didn't come in that first trial?
The alleged confession did not come in that first trial.
And then the second trial, mistried, but the jury didn't hang. It didn't get that far, right?
That's correct. That was it was a mistrial because of comments that Ms. Heather Gwynn made relating to
Other charges.
another crime. There was no physical evidence in the case. The identification, neither of the clerks noticed a scar that was on Mr. Casey's or near Mr. Casey's left eye. And they had identified this Ryan Nave as someone similar, saying that he was 50 pounds heavier, didn't point out that he was, there was a difference in the hairline between the two of them. Heather Gwynn, to whom the alleged confession was made, there was lots of problems with her credibility. She was a 3-time convicted felon. She had 2 crimes of dishonesty. She had made prior inconsistent statements. She was an admitted drug addict. She was a drug user at the time of this alleged confession at the time that this alleged confession was made. She didn't report the crime immediately to law enforcement. So all those factors make her credibility less than stellar.
Have you looked at the video, the surveillance video?
No, that wasn't sent up. From the record, from the closing argument of both the defense and the state, they describe it as too grainy for the jury to make any determination of identity.
Even the enhanced one?
Correct.
Okay.
But DiGiulio says that overwhelming evidence even is not sufficient to find error harmless. You have to determine, is there a reasonable possibility that the error could have affected the jury? If there is, it is harmless. It is harmful by definition. And in State versus Lee, which I've cited in my brief, the evidence there was described as overwhelming, even if not conclusive. But yet the evidence was found to be harmful error and a new trial required. So I would ask that the court reverse and order a new trial.
Okay, thank you both. That completes our